The first cause of the Brown v. Board of Education case was the Plessy v. Ferguson and Jim Crow laws that made segregation legal. Ultimately, Linda Brown's family believed that segregation should be outlawed because black-only buildings and buses were often lower in quality. Linda had to walk across a dangerous railroad track to get to school, while other children also had to travel long distances. There was a school closer to their home, but unfortunately it was a whites-only school. The Brown family sued the Board of Education of Topeka, arguing that segregation hurt black children because their way to get to school was more dangerous than the white people's way to get to school. They also argued that segregation violated the 14th Amendment, stating that all citizens should be treated equally. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Before the Browns case, there was the Roberts case in 1848. Reverend Benjamin Roberts wanted his daughter to have the opportunity to go to school. The case was shot down by the separate but equal stance. Along with Roberts, the Plessy v. Ferguson case also got shut down in the same way. These unfortunate cases ultimately did not lead up to the Brown v. Board case, where it would be anticipated that the Browns would get the same response. However, they did not, and schools, among other things, are now no longer segregated. The Brown family was obviously not the only family struggling with this problem, and many parents and students were willing to come forward and show their support for this cause.
Thurgood Marshall, the head of the NAACP Legal Defense and Educational Fund, served as chief attorney for the plaintiffs. But in September 1953, before Brown v. Board of Education was to be heard, Vinson died, and President Dwight D. Eisenhower replaced him with Earl Warren, then the governor of California. In the decision issued on May 17, 1954, Warren wrote that in the field of public education, the doctrine of separate but equal has no place. As segregated schools are inherently unequal, as a result, the court ruled that the plaintiffs were being deprived of the equal protection the laws granted by the 14th Amendment. This case was a consolidation of cases arising in Kansas, South Carolina, Virginia, Delaware, and Washington, D.C., relating to the segregation of public schools on the basis of race. In each of the cases, African American students had been denied admittance to certain public schools based on laws allowing public education to be segregated by race. They argued that such segregation violated the Equal Protection Clause of the 14th Amendment. The plaintiffs were denied relief in the lower court based on Plessy v. Ferguson, which held that racially segregated public facilities were illegal so long as the facilities for blacks and whites were equal. This was known as the separate but equal doctrine. Chief Justice Earl Warren delivered the opinion of the unanimous court. The Supreme Court held that the separate but equal facilities are inherently unequal and violate protections of the Equal Protection Clause of the 14th Amendment. The court reasoned that the segregation of public education based on race instilled a sense of inferiority that had huge detrimental effects on the education of personal growth for African American children. Warren based much of his opinion on information from social science studies rather than court precedents. The decision also used language that was relatively accessible to non-lawyers because Warren felt it was necessary for all Americans to understand its logic.
Attorney for the plaintiffs was Thurgood Marshall, the head of the NAACP Legal Defense and Educational Fund. Later, after the verdict was that the segregation of black and white students in public schools was unconstitutional, Governor Orville Faubus of Arkansas was a key individual who did not approve of this and got help from the State National Guard to help black students from attending high school in Little Rock in 1957. However, President Eisenhower counteracted his effort and brought in federal troops so the 9 students, called the Little Rock Nine, could enter Central High School.
The Browns, in their numerous cases, argued many points against segregation, such as the fact that it violated the 14th Amendment, which made it unconstitutional. They also emphasized the fact that the separate but equal laws were not equal at all, amplified by how Linda Brown had to walk miles passing by white schools to get to her own school. Their efforts were backed and supported by many other citizens, including lawyers, parents, community activists, and students.
One method they used to cause change was the Civil Rights Act of 1964. It was backed by enforcement by the Justice Department, and it began the process of integration. This piece of legislation was followed by the Voting Rights Act of 1965 and the Fair House Acting of 1968.
During times of slavery, slaves had to risk everything in order to educate themselves. If they were found able to read, they would be heavily persecuted for it. This is because educated slaves were seen as more likely to be disobedient and prone to violence. Education for African Americans was always an extremely low priority until the Emancipation Proclamation granted them the right to have the education that they needed. After this, literacy rates began to slowly increase. After slavery, many freedmen's schools were constructed, such as Howard and Fisk Universities or Hampton College. However, freedmen's schools were targeted and burned. African American students and teachers were persecuted. In terms of education for children, segregated neighborhoods usually had a respective school. In the white schools and neighborhoods, there was higher income housing and administration was paid a larger amount than the colored schools and neighborhoods. This segregated education led to an unequal quality of education between white and colored students. Cases such as Plessy v. Ferguson and Brown v. Board of Education helped pave the way for education equality through the emphasis on the 14th Amendment and the unconstitutionality of Jim Crow laws. To this day, education equality is a slow process. The Grutter v. Bollinger case in 2003 gave the Supreme Court a realization that most universities strive for diversity, yet all the student bodies are predominantly Caucasian.
Education equality is still being discussed today because of the treatment of different students. According to the Education Equality Index, yet in 2015, at only 4% of schools did students from low-income families achieve at the level of their more advantaged peers nationally. This shows how still in today's society, a majority of children who grow up in a poor community do not have an equal amount of resources to perform at the level of their wealthy counterparts. For example, in Odessa, Texas, the test scores averaged 25 out of 100, and this is one of the most impoverished areas within Texas. With the average test scores being of 75 and in more wealthy areas up to 95, this shows the difference in education based on wealth. People today address this problem by attempting to make more fair education systems. To do this, more government funding is supposedly going towards those in need. However, in reality, the amount of funding needed versus the amount provided is not near similar. The debate comes into play when wealthy taxpayers argue their hard-earned tax dollars should go to their local schools that their children will have to attend versus the low-income schools in other parts of the state.
Today, the problem is still education inequality between people of different races. Despite the effort to improve this problem, since the 1954 Brown v. Board of Education decision that segregation in public schooling is unequal, it is still a problem we are facing today. One of these problems is the schooling conditions in which most African Americans have to work with. According to an online database, it says, although black students make up 16% of the population, 41% of these black students were enrolled in urban, predominantly minority schools in low-income areas. These black students were not getting quality schooling for their learning and instead are put into low-standard schools. Another study from the Office of Civil Rights says that in the 3,378 school districts examined, black students were twice as likely as whites to be suspended, receive corporal punishment, or to be placed in special education classes. African American students evidently receive more punishment in the classroom, which could be considered unfair treatment. To further prove this, Mary Hatwood Futrell, president of the National Education Association, agrees by saying, teachers often deal with students of a different race in a discriminatory way because of their own biases and backgrounds. This problem is not solved yet, and both races can agree that more money and effort should be incorporated to reduce education inequality.
The American Civil Liberties Union is an organization that works to give education equality to all American children, regardless of race, religion, social status, etc. They get to emphasize the right that all children in America can go to a public school and freely get an education. In addition, the Equal Educational Opportunities Act of 1974 prohibits discrimination of students or staff, and this includes segregation.